So, good day, ma'am. We are the Group 4 and we are assigned to report the intellectual property rights. And by the way, I'm Jensen Oberholst and I was assigned to report what is intellectual property rights. So, here are the objectives of intellectual property rights. Demonstrate understanding of the intellectual property, identify the various types of intellectual property, and determine the importance of intellectual property in business. So, what is intellectual property? Intellectual property or IP refers to creations of the mind such as inventions, literary and artistic works, designs, and symbols, names, and image used in commerce. IP or intellectual property is protected in law by, for example, patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking balance, the intellectual property system needs to balance the rights and interests of different groups of creators and consumers, of business and their competitors, high and low income countries. An efficient and fair intellectual property system benefits everyone, including ordinary users and consumers. So examples, here are some examples in patent system. So in the patent system, rewards researchers and investors, while also ensuring that they share their knowledge by making patent applications publicly available, which helps stimulate more innovation. And in copyright protection, example, the multi-billion-dollar film, recording, publishing, and software industries, which bring pleasure to millions of people worldwide, would not thrive without copyright protection. And last, in trademark protection. Trademark protection discourages counterfeiting so business can compete on a level playing field and users can be confident they are buying the genuine article. So what that is intellectual property. Intellectual property has five there are five types of intellectual property and that will be discussed by the other reporter and that's all about my report. Thank you.
So, good day everyone. I am Perja Sant Alonso, assigned to discuss about copyright. So, there are many types of intellectual property. One of that is copyright. Copyright or author's right is a legal term used to describe the rights that creators have over their literary and artistic works. So, copyright protects the expression of an idea. So, meaning it protects creative works that covered copyright range from books, music, paintings, sculpture, and films, to computer programs, databases, advertisements, maps, and technical drawings. On the other hand, copyright does not cover ideas, procedures, processes, systems, methods, concepts, and discoveries. Since fixation is one of the requirements for copyright protection, those works that have not been fixed in a physical form or tangible form of expression are not covered under the Copyright Act. So the dictionary defines copyright as a person's exclusive right to reproduce, publish, or sell his or her original work of authorship as a literary, musical, dramatic, artistic, or architectural work. So meaning only the copyright owner can do or authorize certain acts. This includes the right to copy their work, distribute copies of their work, rent or lend their work, and sila rasad ang naay right to perform or show their work and communicate it to the public, including online, or adapt their work, like for example, a book adapted into a play. And since they have the right for their own works, they can sue someone for copyright infringement if they violates the law and or if someone copy or use their work without their permission or without proper agreement. So Image and text are the two most common types of copyright infringement plagiarism, whether music lyrics, academic writing, or stock photos. Usually using them without informing the owner counts as copyright infringement na. So there are ways for you to avoid copyright infringement. If you really need that work of somebody, then you have to seek further permission. Then if possible, give credits to the owner of the work. So when can you say the work is protected? Your work is under copyright protection the moment it is created, and again, it should be fixed in a tangible form that is perceptible either directly or with the use of machine or device to prove that the work is yours. So again, the moment you create an original image, then you automatically own the rights to that image. So what does it take to get copyright protection? So first, the work must be independently created by the author. Second, it must be at least minimally creative. Third, it must be fixed in a tangible form or medium. So copyright protects expressive content, not the underlying ideas. So as I've said earlier, ideas are not covered in copyright protection. So it's important to understand that copyright law covers the form of material expression, not the actual concept, ideas, techniques, or facts in a particular work. This is the reason behind why a work must be fixed in a tangible form in order to receive copyright protection. So, di ba, tangible form means something that can be touched or be able to shown or experience. So, you should be able to show or let people hear the recorded version of the outcome of your idea. So, if you can't, then that would not be protected as copyright since there is no proof man nga ikaw ang nakauna ng idea. So, your work should be in tangible form. So a couple examples of works being fixed in a tangible form includes stories written on paper and original paintings on canvas. So notice how ideas of the author converted into a work. So a physical form nga makita sa mga tao and a work where people can listen or hear live or through records. So now, let's move on to a copyright owner's right. Palihog next balls. So the primary goal of copyright law is to protect the time, effort, and creativity of the work's creator. As such, the Copyright Act gives the copyright owner certain exclusive rights, including the right to reproduce the work. So as I've said earlier, since they are the owner of the work, then they are also the only one who can reproduce the work they've created. If not, then they can sue or file a case to someone who violates the law. Then they can prepare derivative works. So derivative works are based on the original work of someone. So it means that it is an imitation of others' work. Magkuha sila og ideas from the original work. Then they can distribute copies of the work by sale, lease, or other transfer of ownership. Then they can also perform and display the work publicly. We'll go next. So for the application process, to obtain a copyright protection, so one needs to fill out an application form and after that, attach a copy of your work na imuha ipa-register and then pay the basic filing fee of 625 Philippine peso at the IPO. So that ends my report. Ms. Nugget will continue to discuss her assigned topic. Thank you.
So, am I audible? Okay.
Yes, ma'am.
So, good evening, everyone, especially to Ma'am Pastor. My name is Junalyn M. Nogat, and the topic that was assigned to me is about patent. So, at the end of this report, you will learn about patent. What is patent? Why are patents is important? The three types of patent, application process of patent, and its examples. And now, so let's start. So, patent is an exclusive right granted for an invention. So sa Bisaya pa ang patent kay mo na siya ang way na para ang imuha invention kay ma-protect bosa na siya ang way na ikaw jud ang nag-invent ana. Ila ihatag sa imuha ang title na kini siyang imo kining tag sa imo na ang imuha ang title na kini siyang imuhang gi-invent kay imuha gikan, dili nimo kinopya or gikuha na invention kundi imo jud own idea mo nang importante jud na kay patent kay sa imuha invention. So once the owner or inventor accept his or her patent, then he or she has the right to do whatever he or she wants to his or her invention. So and also this provides the patent owner with the right to decide how or whether the invention can be used by others. Lagi ito, ako gingon. Then, also, let's imagine na kanang na timingan lang jud siya na timingan siya na nay usa ka tawo na same og invention. Pero dili mo magkaila or basta wala jud may connection sa usag-usa. Kay basta unexpected lang jud siya na panghitabo. So kini siya so kinsa may ma-consider as patent. So naay gitawag na first to file. So the applicant who files first will get a patent. Bisa pa nag same year, same week or same day ninyo give invent basta kung kinsa tong mauna maka-file mo na to ang makadawat og patent siya ang i-consider na inventor ana nga invention. Then let's talk about the non-patentable invention. So, unsa may mga invention na di ma-considered as patent. And one of that is the mathematical formula. So, you cannot patent your own formula just like Einstein formula. So, Einstein, cannot patent his own formula bisan pa nag-iya hag-invent because it is a mathematical method. Then the next is the invention of machine but it is illegal. So, like kanang let's say fake money. So, bawal yun na siya. Di ba? Kay, syempre, illegal man siya. So, di yun na siya ma-consider as patent yun. Yeah, next please. Now, let's tackle about the three types of patents. So, there are three types of patent. And one of them is utility patents. So utility patents covers anyone who invents a new and useful process, article of manufacture, machine, or composition of matter. It protects the frictional, and this will lasted for 20 years. Then the second one is the design patent. So it includes an product, only protect the non-fictional appearance of the design. So it means ang look sa design, mura ilang kuan, mo nang meaning sa design patent. And this will lasted for 14 years. Yeah. And lastly, the third one is plant patent. So it goes to anyone who produces, discover, and invent a new kind of plant capable of reproduction. This covers a new plant that has been made by a person and it lasted for 20 years. Now that we all know what is the patent, what are the patents, so let's proceed to its application process. Next, please. So, number one is one need to fill out a request form for a grant of Philippines patent, as well as submit description and drawing. So if mag-fill up ka, dapat na naka-ready na to ang imuhang isubmit na description o drawing sa invention or iyahang process. So manang imo first na buhaton. The next is number 2, once the application has been filled, it will be published in the IPO Gazette. So during the period of its publication, anyone can write in or contest the application. Now, what is IPO Gazette? So IPO is abbreviation of Intellectual Property Office. So they own publication where all matters requires to be published under the IP code that shall be published. Then number 3, responding filing fees amount to 3,600 and 1,800 for big and small invention, respectively. The next, please. So this one is an example of patent. So as you can see in this screen, it is Michael Jackson's shoes where he used it in Smooth Criminal song na katong nilindan siya. Nakita naman na kanang Smooth Criminal nga song na katong nagdance siya na siya yung move na naglin siya for which he patent his anti-gravity shoes. So since na-patent kini siya nga invention, did you kaani makasundog or unsa man kay nag-authorize na ni siya as patent. So I think that's all for my report. Thank you and God bless.
Good evening, ma'am. I am Steve Antolo. So, in continuation to our report, my topic is what is a trade secret? A trade secret is any practice or process of a company that is generally known outside of the company. Information considered a trade secret gives the company a competitive advantage over its competitors, and it often a product of internal research and development. Trade secrets are intellectual property or IP, rights on confidential information which may be sold or licensed in general. To qualify as a trade secret, the information must be commercially valuable because it is secret, be known only to a limited group of persons, and be subject to reasonable steps taken by the rightful holder of the information to keep it secret, including the use of confidentiality agreements for business partners and employees. The enterprise association used disclosure of such secret information in a manner contrary to honest commercial practice by others. It's regarded as an unfair practice and a violation of trade secret protection. The importance of protecting trade secrets. Trade secrets are important component of a business that requires protection. Generally, trade secrets include information that has economic value and is not publicly known. It is it is important to take reasonable steps to keep trade secrets from being revealed and to keep them secret. Trade secrets that a business owner may wish to protect can include formulas, methods, programs, techniques, processes, customer lists, customer requirements, product specification, pricing strategies, and recipes. And then it is important to take reasonable efforts to maintain secrecy of trade secrets. Recommended actions to maintain confidentiality of trade secrets include keeping all materials in a secure place, marking documents as confidential, limiting sensitive information access to employees that need to know only, and having employees with access to sensitive information sign non-disclosure agreements. Next slide, please. What are some examples of trade secrets? Example of secrets can include engineering information, methods, processes, and know-how to tolerance and formulas, business, financial information, computer programs. And an advantage and disadvantage of trade secrets. Trade secrets can be misappropriated when they have been disclosed through improper means, such as theft. Additional methods of misappropriation can include bribery, misrepresentation, breach of duty, maintain secrecy, and electronic or other forms of espionage. Misappropriation of trade secrets may be prevented through an injunction or restraining order. Monetary damages may also be awarded in certain circumstances. Maintaining the secrecy and security of trade secrets can be important component of a thriving business. As a result, it is important for business owners to understand how to maintain their trade secrets and what to do to take swift legal action if the confidentiality of their trade secrets entreated or compromised. That's all my report. Thank you. That's all my report.
Mabatera. Hello.
Yes,
Mabatera,
Mate
guys.
Brian.
So, um, tapos na tayo no sa copyright, sa patent, sa trade secret, no. So, let's tackle naman ngayon trademark. So, my name is Brian James Piamonte and I'm one of the um, group members of this of the group 4. So, what really is a trademark, no? So, a trademark can be any word, phrase, symbol, design, or a combination of these things that identifies your goods or services. So the word trademark can refers to both trademarks and service marks. So a trademark is used for goods while service mark is used for service. So trademark. So what do you think ano yung naiisip nyo? So pag naririnig nyo yung word trademark. So kunwari nagsiset up kayo ng brand or bagong company. So, kailangan nyo yung trademark, no? Kailangan nyo ng trademark para makilala kayo ng tao. So, gagawa kayo ng symbol or design or drawings or something na para maalala niya kayo. So, let's say for example, 7-Eleven. So, 'di ba? 7-Eleven word or the brand itself is so worldwide na known, no, kasi nakikita natin siya palagi. I don't know, any corner of the city parang meron yata, no, or di kaya Adidas na shoes or ano pa ba, Adidas, Nike, yung parang may check na sapatos, and ano pa ba, um, or pin shop na na damit, 'di ba? So trademark itself is yung use ng trademark is para makilala kayo ng mga tao, at yung trade service is yung serbisyo nyo sa tao, kung paano nyo iingganyo yung tao para makilala yung yung brand or your symbol or your phrase, or kung paano kayo makilala as a company or as a brand. So next please. Next slide po, please. Thank you. So, there are generally 4 types of mark that can be federally registered. So, trademarks. So, yung nga sinabi ko kanina, trademarks, service marks, yung sinabi ko din kanina, yung service nyo, and your collective marks, and certification marks. So, hindi na natin to papahabain kasi medyo mahaba na yung oras na na-consume natin. So, let's proceed sa kung paano natin i-file or yung application process ng paggawa ng trademark. So, one need to fill out the trademark application form as well as attach a drawing of the mark. So, same lang din no sa kung paano tayo mag-process ng patent at saka ng copyright. May i-fill lang tayo ng mga forms, no, at mag-attach din tayo ng mga tawag dito, yung mga drawings or yung mga product na gusto nating i-process or ipaano sa tao. So it corresponding filing fees amount is 2,160 Philippine money and 180,000 1,080 pesos for big and small marks respectively. So next po.
Ano tayo mo, Brian?
Tama na to. So, yun na pala, yung report ko. Medyo maiksi lang, inisiyan ko lang kasi medyo malaki na yung time. So, that's all for my report. And itutuloy to ng ating pinakagwapo, no? Pinakagwapo natin at pinaka-last member namin na si Mr. Sinarillos. Please, take the floor. Thank you.
So, sige, salamat, Bri. So, hi everyone. Good evening. My name is Dwetkin Sinarius. I'm the last reporter of this report, which is entitled Intellectual Property Rights, and my assigned topic, which is industrial design. So, according to WIPO, an industrial design refers to the ornamental or aesthetic aspect of an article. A design may consist of 3D features such as the shape or surface of an article, or 2D features, which is patterns, lines, or colors. Industrial designs are applied a wide variety of industrial products and handicrafts. So, an industrial design refers to the ornamental or aesthetic article. So, what does this mean? So, well, to further understand, let us consider is two pictures. So, next, miss. So, designs are concerned with pictures that appearance of a part of the whole product. Two-dimensional features such patterns, lines, or color. Three-dimensional features such as shapes, textures, and or surface of an article are protectable by design right after they are not dictated by functional considerations. So, ako balikon. So, ang first, the 3D features refers to the shapes, texture, or surface of an article. Second, the 2D pictures. These are patterns, lines, and colors. So next. Registration of design confers on the owner for limited time the exclusive right to use the design and the authorize others to use it. It also includes the right to make, offer, put on the market, import, export, or use a product which the design is incorporated or to which it is applied, or to stock such a product for those purposes. The maximum duration of design protection varies from country to country, from 5 to 255 years. So, from what I have said, we can now visualize what is an industrial design, and we can observe it usually on a wide variety of industrial products as well as handicrafts. Now, have you noticed that products packaging play a great role in the market world? This time, try to recollect your shopping experience. Have you ever compared to similar product but ended up buying the one which more appealing and creative packaging? If yes, then you just prove how industrial designs impact the choice of customers in the market. So, if you are trying to launch a business, give it a shot for your design. So, did you know your design can obtain the right to be protected and be exclusive for your use, or authorize others to use it? The key is register the design under your name or the owner's name. The maximum duration varies from country to country within 5 to 25 years. Always remember, industrial design is intellectual property. And that's all our report. Thank you and good evening.
So that's all about our report, which is the intellectual property rights. Thank you and God bless.